Get started. Thank you so much for joining us tonight for the latest installment of the S.T.O.P RadTech meetup group. Tonight we're going to be talking about reverse search warrants and geolocation tracking. So how has mass geolocation tracking been expanding? What's being done to fight it? And what can all of you do to help? Really excited to have a couple of amazing panelists with us tonight. But just as a bit of background, this is a joint venture of RadTech and the Surveillance Technology Oversight Project. RadTech is a meetup group based in New York City devoted to exploring cutting-edge issues around technology, civil society, and issues like the reverse search warrants we're going to be discussing tonight. S.T.O.P is the Surveillance Technology Oversight Project. We're a New York-based civil rights group that focuses on fighting the expansion of government surveillance at the state and local level. And that lovely sound effect shows that my email program has not been closed yet. So that will be shut down. Obviously, with Zoom, there's always the lovely technical surprises. One reality is that tonight we may have a few interruptions because our first panelist is Assembly Member Dan Quart, who is still in session up in Albany, and so he may be forced at times to go for votes, roll call votes as they are still in session. Dan is the Assembly Member for the 73rd District of New York, which includes the Upper East Side, Midtown East, Turtle Bay, Sun Place. And since being elected in 2011, he's been a staunch advocate of criminal justice reform, fighting for working families here in New York. He's has experience as a pro bono and 18B criminal defense attorney, and made criminal justice reform a central goal of his legislative agenda. And one thing that's really crucial to Dan's background is he is the sponsor in the New York State Assembly of the reverse search warrant ban that was introduced just a few weeks ago, and is the first legislative response in the country to this growing threat to our civil rights and our privacy. Michael Price is our other panelist. He's a senior litigation counsel for the National Association of Criminal Defense Lawyers Fourth Amendment Center, which provides training, resources, direct legal assistance to preserve privacy rights in the digital age. He previously served as the senior counsel for the Brennan Center for Justice at NYU Law Schools, and in the Liberty and National Security Program, where he worked to oppose discriminatory surveillance, discriminatory immigration practices, and develop legislation to enhance police oversight and accountability. One of those bills is something we worked on quite a bit, which we might talk about just briefly later, called the Post Act. And of course, I didn't introduce myself so quickly. My name is Albert Fox Khan. I'm the executive director and founder of the Surveillance Technology Oversight Project, and really excited to have this conversation. So, I would say, let's start this conversation off by just talking a bit about why reverse search warrants, why geolocation bans are so dangerous. And maybe we could go through both of you, first the Assembly Member, then Michael, talking a bit about what keeps you up at night most when you think about the power of reverse search warrants and these sorts of geolocation tracking.
Thank you. Thank you, Albert, and thank you for the group for inviting me tonight. I appreciate it. What most bothers me about reverse search warrants is two things, really. The abuse of the Fourth Amendment, law enforcement's overbroad, expansive powers over the individual, and the deprivation of those rights of privacy that are intrinsic to all of us. And secondly, and less probably spoke about, is what happens to the data once it has been taken unsecured in an unconstitutional way, and the continuing wrong that happens by the states securing and taking of individuals' data in an unconstitutional way. So those are the two things that bother me the most. I came to this about 18 months ago with an incident that actually happened in my assembly district on 84th Street and Lexington Avenue when the Metropolitan Republican Club determined to an individual from this organization, from the Proud Boys, come and make a speech. The Proud Boys is on the Southern Poverty Law Center's list of organizations that practice in white supremacy. And what happened was the NYPD in the 19th precinct was well aware of their presence. This is the second time within 12 months they were invited. They had 40, 50 police officers out on the street, but for reasons we won't go into tonight, their deployment strategy failed. They failed to make many of arrests, and essentially they had allowed rioting. The only ones they arrested were one or two people from Antifa that really had not engaged in any criminal conduct. But the failure of the NYPD that night, and it's not anything I didn't say to my local captain in precinct's face. I just don't tweet out things. You have to be honest with the officers that you have 40 some odd officers on the street and that they failed to make proper arrests. But that failure then morphed into the district attorney's actions of using reverse search warrants to try and help the NYPD make arrests and secure prosecutions. As best I can tell, Cy Vance used reverse search warrants to try and geofence and locate individuals who are in and around 84th Street and Lexington Avenue at a certain time at night. No arrests were made, but nobody knows what happened to the data that the Manhattan District Attorney's Office took. And it was that experience as a local assembly member within my own district, failures by the NYPD local precinct, compounded by what, in my view, an unconstitutional effort by the district attorney, only justified by saying, well, these are bad people, so we need to make and I felt that struck on the scales of balance, just was not right, and that you don't make up for the failures of law enforcement or the failures of investigatory techniques or tools by then compounding that problem with really questionable search warrants and tactics. And that was my introduction to the use of reverse search warrants, to see how expansive they are, how often they're used, not just by the Manhattan District Attorney, but federal law enforcement and others. And the reason why I became involved in this effort and to try to pass legislation this session or next session, ending the practice, because I think we need bright lines. I don't think we need a bill with caveats and exceptions and carve-outs and looking at particular instances where it may be okay or maybe not. I think it should be banned. I think it tilts too far in all circumstances to infringing upon people's constitutional rights. And that's why I wrote this legislation with Albert and others, and why I will fight for its passage this year or next year or as many years as I have in the legislature. So that's a very long answer to your short question, Albert, but thank you.
No, but I think that helps get to a lot of the things that I think about when I think about the dangers of these sorts of searches. Michael, what about you? Uh-oh, we may be having our first Zoom glitch of the night. Mike, are you still there?
I'm here. Can you hear me?
Uh-oh. We, as so many of you know, that we sometimes get these bandwidth issues and people freeze up for a sec. It looks like you're live again.
Am I here? Yes. Okay. So, of course, I'm supposed to be a technology expert who says going wrong. What else is new? And I was going to say thank you, Albert, for inviting me. Thank you, Assemblymember Quart, for your interest and your work on this issue. What strikes me about, I call them geofence warrants, but reverse warrants is a good way of looking at it, because what they do is they upend the Fourth Amendment. They take the normal warrant process and they turn it on its head by identifying a really large cache of data and then going to search it for whatever they deem to be suspicious. When we first started, the Fourth Amendment Center has been litigating these issues for a while now. And when we first started looking at cases that involved geofence warrants, what was troubling to us was how broad that radius was in some cases, and how many people could be swept up inside of the geofence, especially in a crowded city like New York. If you have a geofence of 100 or 200 meters, you're talking hundreds and thousands of people. And so within that geographic space may be protected spaces, meeting spaces, churches, for example, synagogues. I have one case in Virginia where the geofence included, it was a bank robbery, but the geofence included the entirety of a very large church, apparently for no good reason. And, that is troubling. It was unnecessary collection. It was collection of highly protected private information under the First Amendment and the Fourth Amendment. It was handed over to law enforcement without a second thought to those considerations. But what struck me the most when we started working on this is that we realized it's not just the people inside that geofence who are getting searched. So unlike a tower dump, if you're familiar with that, or searches of people's cell phone location area or information in one area off of a given number of towers, there's an upper limit to how many folks get pulled into that dragnet. But what Google is telling us here, we got a subpoena response from them the other day. They filed an amicus brief in our case saying this. They're saying this is broader than any other search you can imagine, because we can't limit our search to the people that were in that area. We have to search everybody that has location history enabled on their phone. And they said every time they do that, it means they search everyone with location history. They say that is numerous tens of millions of users that get searched every time. There's no way to constitutionally search tens of millions of people at a time. There doesn't seem to be any way technologically to limit the scope of that search, and the size of it is just unprecedented in Fourth Amendment history. So when I look at these things, they are some of the scariest things around, and I don't see any way to make them constitutional. So I think a ban makes a lot of sense.
And I always like starting with rooting this in a discussion of what the harms are, what the stakes are, just so people have that first in their mind. But a lot of people on this call, they haven't heard of reverse search warrants or geofence warrants before. So I was hoping we could go step by step through how that process works, just so people can understand what the mechanics are there and how that differs from the traditional search. So if I'm, let's say the NYPD, what do I do? And I want to know about people in a certain area. What would the next step be for me to take?
So for these geofence warrants, there's no way to make them particularized, really. They're plug and play warrants. You can download a template from a couple of companies online. You put in your geofence coordinates, so, latitude and longitude, and say how big a search you want Google to conduct. And I've seen that, be a few hundred meters to much larger than that. And the government will send that, get approval for it. It's a warrant, so they're supposed to present it to a magistrate or a judge, and then they send it to Google. And Google will respond with a 3-step process that they created to handle this. And in the first step, they will search everybody with location history enabled on their phone, so numerous tens of millions of people, in order to identify the devices that were within that radius over a given period of time. So that may be an hour, it might be 2 hours. And Google will then send back what they call anonymized information about those devices to law enforcement. Interestingly enough, that data is masked, but it is in no way anonymous. So in a number of cases, ones that we're involved in, we've been able to identify people by name from that anonymous data just because of how revealing it is. But at the end of that process, the government is supposed to narrow down the list of devices of interest, and then they go back to Google and they say, here is a list of devices of interest. We want even more location data on those devices. We're going to take off the geographic restrictions, we're going to lift the geofence, expand the amount of time, and see where these people are coming and going. And so then you'll get a second production, the stage 2 production, which is also in its masked or pseudo-anonymous form. And then in round 3, law enforcement will go back to Google and say, here's our top 3, tell us those usernames, give us all the information that you have associated with those accounts. And so that's how it typically works. I've seen warrants that do it in 2 stages or 4 stages, but the general idea is the same. Google does a massive search. It hands a bunch of data over to law enforcement to look through and identify whatever it determines to be of interest, and then they get more information from Google in the later stages.
And one of the things I find fascinating about that is because of the way you're searching everyone's location history. And for those of you who haven't seen how these operate before, you basically are drawing a map, like a square on Google Maps, and saying, give me the information for everyone inside that square. And the thing is, if you're casting a large enough net, you're always going to find someone whose device appears to meet the pattern that you're looking for. This is why it increases your rate of false positives. So, I think as someone who's done work in the wrongful conviction space, it's very easy to imagine people who just happen to look like they are responsible for a crime because they were in the wrong place at the wrong time, not because you're actually systematically identifying the people who are responsible.
Albert, it's interesting. You mentioned false positives. There's one thing I should probably add, which is because of the way that Google calculates its location data, we've found there are in fact a lot of false positives. In one case where the government said, here's 19 people that fell within this geofence, we figured out that like 6 of them were never inside of it at all. And it has to do with the way location information is sort of estimated and calculated. Sometimes it can be very precise. Sometimes when it's working off of, say, the church Wi-Fi, it identifies people, I'm not kidding, who it says they were in that space who were never in that space. It is something that Google acknowledges now, this idea of false positive and the ability to sweep people into that geofence who were never even there. So, I couldn't let that go. I just flagged that for you.
As always with our discussions, it's worse than you thought. The technology is even more problematic. So, Assembly Member, I wanted to think about what this means in the day-to-day lives of your constituents, because it's not just Google, but we see these requests from the Manhattan District Attorney's Office to Uber, to Lyft, to payment processors. What do you think that does to people who just want to be able to go about their lives without second guessing every decision they make and how it will be, potentially interpreted by Cyvance or the NYPD in the months ahead?
It is a deeply troubling practice that is so expansive. I think those who use it, their only benefit is that the public is not truly on notice, if you will, at how their privacy rights are being infringed upon. I would just say, if you look at the last 10, 12 years, this is part of a larger context of the use of technology in a non-specific way to target people. And if you look at just a little history on that, if you look at the end of stop and frisk, Judge Scheinlin in the federal courts said stop and frisk was unconstitutional as applied in New York City. So then Commissioner Kelly comes in and installs something called Operation Crew Cut. I can't make up these names, where the NYPD basically creates a database. They call it a quote unquote gang database. District attorneys have a similar technology, specifically Mr. Vance, and they have their own quote unquote gang database technology, but that's only one aspect of their technology reach over and across Manhattanites, or maybe people in Brooklyn, although I don't know, that district attorney. But this, in the context of the last 8 to 10 years, is the huge expansion of technology. I won't say as a substitute to stop and frisk, because this expansion probably took place concurrent with the existence of stop and frisk, but it is the same types of tools that the federal court said were unconstitutional as applied in New York City. A little is known about the NYPD's use of these types of technology because there's some level of oversight by the city council. Ironically, it was always Commissioner Shea, before he became commissioner, who would always go down to the city council and attest to its limited scope, how you can trust the NYPD. Virtually no oversight has been done on how the district attorneys apply technology. And to your question, Albert, and to your point, it is so many hundreds of thousands of New Yorkers, of Manhattanites, who are having their constitutional rights abridged, violated. And they're unaware of that fact because technology is sort of used as a successor to the physical stop and frisk, although they were also happening concurrent, as I said before. So it is a danger. And that's why I did the bill, because I think there needs to be a bright line here. I don't think I don't see any way that this can be done in a narrow, tailored way for the reasons my colleague spoke about just a few minutes ago. I think the only bright line is a policy determination that the harm done by such policies far, far outweighs any tangible good. And at least from the one incident involving the quote unquote Proud Boys, and the incident 18 months ago or 20 months ago, no arrests were made. So you tell me, where was the tangible good? Where was someone who engaged in criminal conduct on the streets of Manhattan? Actually, nobody was held accountable for this, but many people had their constitutional rights abridged and infringed upon. I think it's an easy call on the scales. And I think it's a very difficult argument for those who support it to say, well, we are making arrests, we are prosecuting people, we are finding people, because there's just no or very little evidence to suggest that ever happens in a meaningful way by the use of reverse warrants.
Yeah, and one of the things that really always stuck with me about that case with the Proud Boys, and I think this is something you touched on briefly earlier, is that in that case, they weren't using a reverse search warrant to go after the people who perpetuated the crime. They were using it to find the victims. They were using it to find the Antifa counter-protesters who had been targeted by the Proud Boys.
That's right.
Which to me makes it only more outrageous in that sort of situation. One thing that I really love about your bill, Assemblymember, is the fact that it not just targets reverse search warrants, but voluntary data requests as well. Requests to data brokers, when requests to companies that would say, sure, here's our clients' records without fighting it and demanding a warrant. Could you tell me a bit more about why you thought it was?
Why did you call me?
Yeah, I think because we have to not just, it can't just be governmental agencies. It has to be broad enough to deal with their enablers and the appendages of government activity who help in the securing of data. And that's why we have the ability to seek punitive damages. And, although that's not a primary goal of the legislation, civil, but the ability to do so is important, because we need to have a broad sweep on the preclusion. And that, I'm sorry, my children are yelling in the background, so I
No,
But that was really the reason, is that if we are going to stop the conduct, then we really need to be looking at those actors who are non-governmental, but who foster the ability of government to act in this way. And that's what we were thinking about.
Yeah, and as I've told our staff at S.T.O.P many times, a law is only as good as your ability to actually enforce it in court. And having punitive damages, having some real penalties is always important.
It needs teeth, yes.
And I was just gonna quickly invite the audience to submit your questions for later on in this discussion. We have the Q&A window and we'll be collecting those throughout. So if there's anything you want to ask related to this topic, please feel to ask there, and we'll be monitoring as we go along. So Mike, I was hoping you could tell us a bit more about the specifics of your case. You touched on some of the details, but just what sort of precedent do you want to establish? And since we have a number of lawyers and law students joining us, could you tell us a bit more about the Fourth Amendment arguments that are at play?
Sure. I'm going to refrain from too much on the specifics of any one case because we're still litigating them. But it started out as one case, and it is no longer just one case. We have a bunch of these now in various places around the country. But in every instance, the arguments are the same. And that is a geofence warrant, a reverse location search warrant, is a general warrant in the sense that it is not specifying any particular user to search and any particular data from Google. It's saying, let's have a look at all of your data, all your location history data. We'll tell you how to search it for devices of interest to us. We'll go back and forth a few times on that without involving the court, and some Google and law enforcement will negotiate over whose data ultimately gets unmasked and handed over. But the search itself is almost unbridled. That there are no restrictions on how many users get searched each time the government submits one of these warrants. The only limit is the number of Google users with location history enabled. And by the way, most people do not know that they have location history enabled. So it's a setting. Google really uses a few dark patterns to make sure that people opt into it without really explaining what's going on. And so you have tens of millions of people walking around with tracking devices in their pocket. Google gets that data. The government gets to rifle through it without any specificity, right? So the Fourth Amendment requires both probable cause, right? And without that, you have an overbroad warrant. It also requires particularity. You have to particularly describe the data that you want to get. And the whole point of one of these warrants is that the government doesn't know what data it wants to get. If it knew, it would just seek the information related to those users, but it's not doing it. So the argument is that it is fatally overbroad and lacking in particularity, that there really isn't a way to cure that. I mean, you can make the geofence a little bigger, a little smaller, but the scope of that search at the end of the day is still enormous, and there's no way to fix that. That said, in every one of these cases, you argue that they shouldn't be allowed at all, that they're overbroad and lacking particularity as a rule. But in each individual case, you can point to facts that say, well, you drew the circle too big. You should have done a different procedure. It was overbroad or lacking particularity in this case. But and I guess the church is a pretty good example in the Virginia geofence case, where there was there was a bank robbery, rush hour on a Monday afternoon outside of Richmond, and the police dropped a pin right in front of the bank, and drew their cursor out by 150 meters and hit send. And they didn't say in the warrant application, I don't think anyone really knew at the time, or at least they didn't tell the judge, that included the entirety of a megachurch, and as well as let me see if I can get this right, a hotel, a restaurant, a mini storage complex, 2 apartment complexes, and any number of small businesses, right? As well as major roads. So, that in and of itself, you would say, well, why'd you include the whole church in there? I thought you were interested in the bank. So you can argue that any individual warrant has its own problems, but the overarching argument here is that general warrant point. And if that's the case, then the only solution is a ban. There's no way to fix that.
And yeah, I mean, when you think about it, for those of us who are history nerds, it does start to resemble the general warrants that existed, before the American Revolution, where you would have British customs officials and other officials with just a piece of paper that said, we can go wherever we want. We can go into your home, we can go into your office, we can rummage through your files. And, that was something that was anathema to the founders. It was something that was seen as one of the most fundamental threats to personal liberty at the time. But when you think about everything that can be acquired through a cell phone search and these sorts of searches, like, I know we can't get to all of it, but I was wondering if you could both talk about some of the types of data besides simply location data that can be swept up in these sorts of searches by associating Google account histories, other app histories with someone's inclusion in one of these reverse search warrants. Sorry, I think you're muted, Assembly Member.
No, I'll let Michael take the first stab at that. So.
I mean, so I can tell you, Albert, the location data that Google collects for these sorts of searches is not just your cell phone tower location information. It's GPS, it's Wi-Fi, it's Bluetooth, and that sort of data, which Wi-Fi network you're connecting to, which Bluetooth devices you were in proximity to, I think tells its own story. The warrants that we've seen, though, at least to Google, have only been seeking location data. I haven't seen them search more broadly based on the content of somebody's communication or something along those lines. But interestingly enough, Google considers this location data to be communications content information. So they require a warrant for that reason. But it's more or less a sign that they believe it is very private, right? That it is on par with searching somebody's email account or text messages. That it is that invasive, that revealing, and I think that answers your question. I don't know if you're asking about what other types of data could be searched more generally that Google has, or that might be on a cell phone.
And I was thinking about the sort of cross, the way that this data, if you're not just thinking about Google searches, but also, your Uber trip history, if that type of reverse search warrant is being used, as we saw in the Upper East Side, where, Uber was asked to identify every account holder who had been in the neighborhood, or payment processors are being at that point, it starts being not just location, but location combined with travel, combined with financial transactions, combined with all these other facets.
And I would just say, Albert, the absence of an actual adversarial process suggests that that the data will be much more expansive than even asked. As Michael described, the back and forth that goes back, but that doesn't go. There's no vetting or any objections noted by the individuals. If I was on 79th Street in a sweep, I think District Attorney Vance doesn't even give notice to the individual, or that was a fight, whether he would. But that's sort of a legal fiction or sophistry, the idea that, well, if you give notice, that each and every person can then retain counsel and pay out of their own pocket to defend their privacy rights. That doesn't happen. So you have government that has expansive and absolute resources, if it really wants the information, and they go back and forth with Google, that is really a corporate actor that's looking to protect itself from civil liability, so that it doesn't get in trouble. It doesn't have to pay out money. That's really its most significant concern. But nobody's there to look after my interests or my rights if I get caught up in that sweep. So I would just assume that everything on my phone is fair game. If they get to round 2 or round 3 with me, that every single thing that exists on my phone is going to be in law enforcement's hands. And I think because obviously beyond the expansive powers of government, and they're going to use all their resources, there's no feasible or reasonable way to employ any attorney protection for the individual. So, and Google's not incentivized to do anything more than protect the company. And if in protecting the company, they protect my individual rights, that's great, but it's an appendage to that. It's not of primary importance to them.
Yeah, and one other thing, on the transparency front that really is mind-boggling to me is that, even if there's notice going out to individual recipients or targets of these reverse search warrants, people who in round 2 or round 3, their data is being sent over. My understanding, Assembly Member, is that we don't know how many times these warrants have been used by local prosecutors or the NYPD.
And if there was why should I have, if I was on 84th Street and Lexington Avenue within 40 minutes of this incident, why should I have to tell the government that, absent some sort of reasonable cause or probable cause, that I was engaged in some violation of the penal code? So it almost, in a way, shifts the obligation that the recipient, the person who's had his or her constitutional rights infringed upon, violated, then almost must come back, almost rebut the presumption of some sort. What were you doing there? Some level of questioning, without direct evidence at all to demonstrate criminal conduct or even probable cause to suggest that. So it has the whole system backwards, and that's why the ban is the only thing that works. This is not. Government has become over-reliant on it because, unfortunately, this is the way in which quote-unquote crime is attacked in many ways, rather than the use of direct evidence or normal techniques of building a case against an individual based upon individualized conduct. In a whole host of ways, as I talked about earlier, we use non-specific data and non-specific tools, where the Fourth Amendment requires specificity when seeking to deprive somebody of their liberty.
Okay.
Yeah, so,
sorry, go ahead, Mike.
No, I was going to say, just to pick up on that funny story, one of the cases that we worked on came out of Florida. And, just as an example, right, this really does seem to be a situation where police are trying to take the easy way out, and they're just going to Google and they say, Google, who robbed the house? And that's what they did in one Florida case we got involved in. And interestingly enough, Google ended up notifying a potential suspect in that case that he was about to have his information disclosed to law enforcement as a result of a geofence warrant. Google also provided him the number of, or the name, the recommendation for the name of the statute and recommendation to go talk to a lawyer about it. Because the guy, there was a home invasion in his neighborhood. He turned up on the geofence data as circling the block repeatedly around the time that there was, some sort of burglary. And he looked like a suspect to police. So police went back to Google based on this geofence reverse warrant data And they said, all right, we want all of his account information now. Give us everything you have on the guy. And they also sent him this email. It turns out he's an avid biker. He lives in the neighborhood. That's his exercise route. He takes it every day. And the police were going to go and get all of his Google data just because he showed up on this map a couple of times and appeared to be a suspect. He was actually able to get the Attorney General in Florida to withdraw the rest of the warrant. And so, that was a success. But it's also a cautionary tale, right? This is somebody who was out for a bike ride in his own neighborhood and could have gotten pinned for a home invasion, or at the very least had his account handed over to Google. This is not the typical way to investigate a crime. Surely home invasions were solved prior to geofence warrants, and conventional tools in that case would have, I think, alerted police that this was not the suspect they were looking for. Instead, they took this easy way out and went to go ask Google.
Yeah, and that's one of the maddening things about techno-solutionism, that when people are using these surveillance systems, they assume whoever looks most like a suspect of the people whose data they get, that they are a suspect, even when oftentimes there's no correlation between what they see and actually being connected to the crime.
Right. This is why particularity is so important, why a judge should be involved in this process. I think, or if a judge is involved in this process, should understand what's going on. I don't think what is being asked of the judges on paper is far different from what actually happens. I think certainly, going for a bike ride should not land you in a police database, should not lead to your account getting searched. What looks suspicious shouldn't really be up to Google and the government to hash out in private. That's something that you lay out in a warrant when you're asking for somebody's specific data. You don't get to go back and forth and say, well, that seems suspicious. Let's poke around in there a little bit more. That really is something that the Constitution decided to leave up to the judges and not to law enforcement. So it's the purpose of the Fourth Amendment. It's the reason that we have the provisions that we have in there is to prevent exactly this kind of thing.
Well, as we've seen from today's executive order, some people in the executive branch have a hard time remembering that the judiciary is actually supposed to play a role in our government. But let me switch to some of the questions, and again, invite all of you to submit them using the Q&A window that we have here in Zoom. So our first question comes from Alyssa Domino, and the question is for Assemblymember Quart. What is the strongest line of opposition you foresee to overcoming in the Assembly, and how do you plan to challenge it? And I'll add as a kicker to that, what can the people in this Zoom do to help?
Law enforcement, the District Attorneys Association, and the various law enforcement lobbying groups in the city. It's the PBA, outside of New York City, Nassau, Suffolk County, Troopers Association. Law enforcement is still a very powerful tool, and it has allies in the media, like certain publications like the New York Post. One only look at the last 6 months on the stories that had only a scintilla of truth about bail and bail reform. So I think they are still a potent opposition, the District Attorneys Association and the different organizations and lobbying groups that represent police in local cities, as well as troopers throughout the state. The onus is, first and foremost, it's a new bill. It's on me to gain support amongst my colleagues. This is an issue that I think requires a little explanation for many legislators who don't have a background. But I think the obvious need for this bill, and that it is just and right. I mean, I believe it's obvious because I'm going to fight hard for this bill. But I think for those on the call to talk to their individual legislators, whether in the state assembly or the state senate, and ask that they become co-sponsors of this legislation. That is a good first step. And I think the other good step is maybe timing, in that the legislature may be in session for the entirety of this year. So the ability to push forth legislation that is non-fiscal, there may be a strange window for us to get some progress on that. But I think the thing that people could do here now is to call their local state assembly member and state senator, ask to speak to them, to educate them on this, and then ask them to be a co-sponsor on the legislation.
And I would also note that for those of you not in New York, we've already worked with some grassroots groups in other states to potentially introduce parallel legislation, and we're always happy to work with you to see how you can get similar bills introduced for your community. So the next one, let's start with Mike on this one. And it's from our good friend Anonymous. Since the Supreme Court in Carpenter explicitly declined to extend its holding to forms or quantities of location information other than 7+ days of CSLI, how do you rebut the argument that collecting this information is not even a search in light of the third-party doctrine? Wouldn't you not even get into the general warrant argument if you don't first establish that it's a search? Clearly a law student or a lawyer, given the amount of amendment documents.
Looking for help with their homework assignment, I see. No, it's, I think it starts by a proper understanding of the court's decision in Carpenter. And the court in Carpenter decided the facts in front of it, which involved 7 days at the minimum of location information that had been collected. They said, we're not going to talk about the other stuff that we know is out there and we know is coming quite yet, but watch what we do and not what we say here. This is a fundamentally different approach that the court took in Carpenter. They said, we're not going to apply the third-party doctrine mechanically. They told courts, you are not to apply these rules from 40 years ago to new technology blindly. You have to consider the privacy interests at stake and then make a determination about whether the third-party doctrine applies. And the court did that in Carpenter based on the 7 days in front of it and said, yeah, that's a search. But I don't think they said in any way, shape, or form that 6 days was okay or 5 days was okay. And I think the other thing you got to recognize here is that the court was making a determination about what could be revealed based on that data in front of it. How private was it? And what we're talking about in this instance, Carpenter was one person. Here we're talking about a search that is much broader than it is deep, to a, I would argue, unconstitutionally overbroad level, right? It's not just one person for a couple hours, it's 10 million people for a couple hours. And that's going to show those associations, certainly within the data returned to law enforcement, just as it would show associations in Carpenter. And Carpenter itself is talking about the privacy interests that are involved with being located in particularly sensitive places, even if that just entails one trip to the Alcoholics Anonymous or to the gay bar or to the abortion clinic, right? It doesn't take a few days worth of tracking to make that sensitive private information. And the other thing I'd say at the end of this is that it certainly ignores the whole idea that you have a property interest in this data and that any infringement upon your property interest in your private papers and effects, which is what Google is saying this data is, right? It's saying it's content, just like your email, it's private paper and effect. If the government is going to infringe on that, trespass on your property rights, it's a search, even if it's small. So I think there's a couple of different theories out there where you can get to a search And certainly once you agree that it's a search for one person, it's a search for 10 million people, it's a general warrant. So Carpenter, I think, requires reading the court's reasoning there and seeing how they got to that result and taking that approach as the court instructs and applying it to the new technologies that they most certainly recognize were coming down the pipeline.
And for those of you who haven't read the decision or aren't familiar with it, really, I can't recommend enough. Just they're looking at some of the summaries online, taking the time to read the case if you can, because I personally, I think this is probably the most impactful Fourth Amendment decision, in recent decades, because it does show exactly what Mike is talking about, this pivot to a new world where courts are looking at, in practical terms, what is the privacy impact of these searches, and moving away from some of the outdated reasoning that would have made it harder to challenge things like geofence warrants in the past. So one aspect of this bill that I don't think was really front of mind when it was first introduced, but is now very relevant, is flagged by our friend Anonymous, and they wanted to ask the assembly member how this would potentially impact COVID-19 tracing data, because I think one thing that wasn't really considered at the time that this bill was created was that in addition to all the location data that's being created by our day-to-day cell phone usage and all of these existing commercial products, we were going to suddenly have a new layer of tracking that was being developed in order to fight this deadly pandemic.
That's actually an excellent question, and something I'm going to have to give some thought to about how trying to track information in the context of this pandemic for asserted public health reasons, and of course it is, but could still result in a continued infringement of people's privacy rights, and how we have to do that. And I would not want to see the pandemic used as a pretense, which I suspect it would and could, as a reason for district attorneys to essentially serve these general search warrants or reverse search warrants, as we call them, in the context of the pandemic. And the reason why that's so concerning is because so much of the law of this state at present is being dictated by executive order. The courts have not gone away, but it's, and if we continue to be in this quote unquote emergency period, I suspect there'll be more challenges to executive orders. And that's a good thing, because if we're being ruled by it, then it has to be challenged for constitutionality. But I am concerned that the use of tracing data in the context of the pandemic will lead or expand already overbroad use of district attorneys of search warrants, and specifically reverse search warrants, as another predicate way to get data from people that has nothing to do with particularized conduct. It's something that we'll have to watch as we go through this pandemic, and hopefully come out of it sooner rather than later. But there's a data collection aspect to the pandemic, and I am concerned that it would be used as another tool by law enforcement in their abridgment of the Fourth Amendment.
And I think that's really a sentiment we all share, that there's this deep fear that in our fight to save New Yorkers' lives and combat COVID-19, there's going to be an arms race to do things in the name of fighting the disease that have nothing to do with fighting it, or to exploit that data collection for unrelated purposes. And one of the things I really love about this bill is that it wouldn't do anything to block public health authorities from contact tracing, but NYPD and other police departments then wouldn't be able to admit that as evidence in court. They wouldn't be able to use that in their criminal cases.
And that is always, with all this technology, that is such, one of the major concerns of many of us is the sharing of information. whether it's the gang database technology or what my concern or what happens after the district attorney secures all this information, we would be deluding ourselves if we did not think there was a constant sharing of information between the NYPD and district attorneys, and that would certainly extend to federal law enforcement, whether that's FBI, ATF, or DA, or anybody else. So the problem is when the wrong occurs in the first instance, and if it's allowed, it's very hard then to sort of get the toothpaste back in, because who knows who then has this information and which branches of government and have it. So that is, again, going back to the bill, why an outright ban is so necessary. And your point, Albert, is very well taken, that we don't want to do anything to stop public health measures, but there's a way to do that with a clear, bright line against sharing of that information with any law enforcement entity.
Well, if I could jump in for 1 second on that, Albert, I think there's no question in my mind that somebody might try to collect this data for that public health purpose, but I don't think that it would be very effective at achieving any sort of public health goal, given what we know about how accurate some of this data is. Some location information, and maybe if you get a really good GPS fix, has a margin of error of a few meters. But most of the time, when you're talking about this sort of location data, Google is only accurate. It says it's only accurate to about 20 meters, 68% of the time, and a lot of the data that we are seeing shows it to be much more inaccurate than that. So if the goal is to try and figure out who was within 6 or 12 feet of each other, this is not the technology to do that with. And so I think it is important to understand the technical capabilities of something like this, which obviously wasn't designed for public health contact tracing. To try and use it for that would be ineffective and just a massive breach of everyone's privacy interests for no good reason whatsoever, right? This is not the data you're looking for.
I keep telling people that these are not the droids you're looking for with photos of droid phones. Yeah, and this would be a great opportunity for me to shamelessly plug our recent white paper on the limitations of technology-assisted contact tracing. You can find it at stopspying.org/Bluetooth, where we look at the Bluetooth-based API that Google and Apple are working on, and the reasons why we think it will exacerbate health inequalities, perpetuate discrimination, and really make things a whole lot worse for New Yorkers. I know we have 2 more questions, but unfortunately we're out of time. But I just wanted to give you each just a moment to tell the audience anything else that you think they should know about this subject.
No, Albert, thank you, and Michael, thank you. This is really a great opportunity to talk about this issue. And Albert, your last question about the potential pitfalls of the use of the pandemic as sort of a manner in which to give law enforcement more tools to abridge my Fourth Amendment rights is deeply disturbing. But I think a good first step, and obviously it's my bill and this bill, but to get progress on this matter, because the legislative process is a long one. It can be arduous. Good ideas don't become law that quickly, even when they're good ideas. So, it took me 7 years to end a statute in New York that allowed prosecutors to take work tools and mislabel them knives and prosecute people for it. So I hope this doesn't take me 7 years. It's my hope I won't be in the legislature another 7 years. But everybody's efforts on helping me in pushing this bill in getting involved in groups like this and talking to your individual legislators would be extremely helpful. And I appreciate your time, and thank you for inviting me today.
Assemblymember Quart, thank you very much for your legislation. I do think it's important and necessary. I guess what I'll say is that in the meantime, the Fourth Amendment Center, with the National Association of Criminal Defense Lawyers, where I work, will continue to litigate these cases as we get them. You all should be aware that it is out there, and please, please, please contact us at 4ac@nacdl.org. If you get a case like this, we have resources, we have briefs, we're able to help litigate it. And so, while we wait for a legislative fix, we'll be in the courts. And thanks very much for your interest.
Well, thank you both so much for joining us tonight, and thank you all for tuning in, and hope you'll join us next month for the next edition of our RadTech S.T.O.P meetup.